Wednesday, Donald Trump just lost his last appeal, $50,000 per day, starting immediately, no stay, no pause. According to court documents filed this morning, the U.S. Court of Appeals for the Second Circuit denied Trump's emergency motion in a 3-page order done over the fines stem from contempt findings in the New York civil fraud case. Every day Trump doesn't comply with document production orders, another $50,000. Math simple, 30 days, $1.5 million, 60 days, $3 million. Court's position: Appellant has exhausted all procedural remedies and demonstrated no likelihood of success on constitutional grounds. Translation: no way out. Trump's legal team filed 47 pages of arguments Tuesday night, rejected in under 24 hours. Here's what the order actually says, page 2, paragraph 3. The district court's contempt finding was supported by clear evidence of willful non-compliance spanning 11 weeks. Daily sanctions are appropriately calibrated to compel performance. Clear evidence, 11 weeks. Willful, 3 appellate judges, unanimous. Judge Sarah Netburn wrote the decision, former federal prosecutor. 18 years on the bench. What makes this different from previous Trump legal battles? No appeals left at this level. Supreme Court's the only option, and legal analysts are saying that's a long shot for contempt sanctions. Former federal appellate lawyer David Hoffman told reporters this morning, the Supreme Court rarely intervenes in civil contempt cases involving document discovery. So the clock started today. Wednesday, July 29th, 2026, $50,000 per day. Let me show you how we got here. Question is simple. How did Trump go from calling this case a political witch hunt to facing automatic daily penalties with no legal off-ramp? I went through the court filings, the appeals, the compliance reports. Patterns clear when you work backwards. This isn't about one missed deadline. Documents show 73 separate discovery requests over 18 months. Each step documented, each warning preserved in the record. What the public saw Trump fighting in court, what the documents show. Systematic non-compliance that painted him into a corner. Let me show you. Start here. Monday, 2 days before this decision. Trump's legal team still projecting confidence. Public statement from attorney Alina Habba. We're optimistic the appellate court will recognize the constitutional issues at stake. But behind the scenes, different picture. According to documents filed Monday afternoon, emergency motion listed 8 constitutional arguments, requested immediate stay of sanctions pending appeal, included 127 pages of exhibits attempting to show good faith compliance efforts. What nobody knew, prosecution had already filed opposition brief Sunday night, 23 pages, devastating. Quote from page 11, defendant's compliance consisted of producing 340 documents after court-ordered deadlines, with 89 documents heavily redacted despite no assertion of privilege. Monday evening, Judge Netburn's clerk issues notice. Decision forthcoming within 48 hours. That's unusual speed for appellate court. Legal observers reading the tea leaves. Not good for Trump. Former Second Circuit clerk Maria Gonzalez tweeted Monday night, fast denials are more common than fast grants. That's the immediate lead up. Now, rewind further. If you want the full breakdown, subscribe. I'm walking this all the way back through 18 months of court filings, compliance battles, and the decisions that eliminated every exit. Okay, go back 6 weeks. This is where it starts getting interesting. June 17th, District Court Judge Arthur Engeron issues the contempt finding that started this whole sanctions spiral. Page 34 of that ruling found this. The court has provided defendant with unprecedented latitude and multiple extensions. This pattern of minimal compliance followed by renewed delay is itself evidence of willfulness. Translation: you've been playing games. We see it. It stops now. What's significant? First time any judge in Trump's legal history used the word willful in a contempt context. Sanctions designed specifically to be coercive, not punitive, meant to force compliance. Built escalation into the order. $50,000 daily unless full compliance achieved. Judge Engeron apparently consulted sanctions precedent from 14 similar civil fraud cases. Timeline matters here. June 17th, contempt order issued. June 19th, Trump files notice of appeal. June 24th, requests stay of sanctions pending appeal. Put those together, yeah, pattern, standard appellate strategy, delay enforcement while fighting the underlying order. But here's what nobody caught. June 24th motion for stay included a compliance declaration from Trump's document custodian, a Delaware LLC called DJT Management Services 3. I read that declaration 4 times, same conclusion. It admits documents exist, but claims ongoing review for privilege has delayed production since March, 3 months earlier. Judge Engeren's response, June 28th order denying stay. Defendants claimed ongoing privilege review is incompatible with the discovery deadline of February 15th, 2026, which passed without objection or request for extension. Implications at the time. Sanctions start immediately. No stay means daily fines begin June 29th. We're now at $1.5 million accumulated. Did anyone act on this? Trump's team filed the Second Circuit emergency appeal 3 days later. Keep going back, further back. February 2026, different documents, same story. Email trail from mid-February. 31 messages between Trump's legal team and New York Attorney General's office. Key exchange February 14th, 1 day before the discovery deadline, from Associate Counsel Trump Legal to Senior Investigator NYAG subject outstanding document requests. Quote, we're working to finalize production by tomorrow's deadline, but may need a brief extension for final privilege review. Responses same day, 3:47 p.m. Any extension request must be filed with the court. We've granted 4 previous extensions over 11 months. Read that again. They knew February 14th, knew they'd missed the deadline. Supporting evidence. Financial records show $470,000 paid to litigation support vendor based in Phoenix is February 8th to 12th. Vendor specializes in document review and privilege logging. 4 witnesses later testified the vendor completed review February 11th, flagged 89 documents for privilege review, cleared remaining 4,300 documents for production. Internal memo from Trump's lead counsel, page 3, dated February 13th, confirms vendor completed work. So vendor's done? Documents ready? Deadline's February 15th? What happened? February 15th came and went, no production, no court filing requesting extension. New York AG's office sends letter February 18th. Defendant has failed to produce documents per court order dated August 2025. Request immediate compliance or court intervention. February 22nd, first warning shot. NYAG files motion to compel and for sanctions. That filing, 63 pages, lays out the whole history. 4 previous extensions granted: September 2025, October 2025, December 2025, January 2026. Each time, Trump's team produced partial documents, then requested more time. What's the through line? Pattern of minimal compliance, repeated deadline extensions, documents ready but not produced, no legal justification for final delay. Every step documented. This isn't speculation, court filings, public record, now opposition perspective, but okay. Full picture, Trump's side has a completely different take on this. Their argument, and it's not nothing. The sheer volume of discovery requests was unprecedented and politically motivated. New York AG demanded 18 years of financial records, communications, and internal analyses across 47 different business entities. Defense attorney Alina Habba argues this amounts to a fishing expedition designed to generate contempt findings rather than discover relevant evidence. Their legal position stated in the June 24th appeal brief, the AG's document demands exceed the scope of any civil fraud investigation in New York history. Compliance requires review of over 840,000 pages across multiple jurisdictions and corporate structures. What they point to, Trump's team actually produced 4,300 documents, more than defendants produced in 6 comparable New York fraud cases combined. The 89 documents withheld on privilege grounds represent 2% of total production. Other high-profile fraud cases in New York received 6 to 8 extensions as standard practice. Constitutional lawyer Alan Dershowitz filed an amicus brief supporting Trump's position. His argument: coercive sanctions that accumulate indefinitely risk becoming punitive, violating due process protections against excessive fines. Even former federal prosecutor Preet Bharara admits the daily fine amount and unlimited duration do raise questions about whether sanctions remain coercive versus punitive. Look, working backwards, you can construct different narratives. Their version: Trump's team made good faith efforts to comply with extraordinarily broad discovery demands. They produced thousands of documents. The remaining 89 involved legitimate privilege concerns, attorney-client communications about litigation strategy. The AG rejected multiple compromise proposals, including producing privilege logs or submitting documents for in-camera review. When Trump's team was days late on the final deadline, the AG immediately moved for contempt rather than working cooperatively. Judge Engoron's contempt finding and $50,000 daily sanction was immediate, and extreme standard practice would be a warning, then graduated sanctions. The appellate courts rubber-stamped the lower court without seriously considering the constitutional implications of unlimited accumulating fines. My read, documents support some of that. The volume was genuinely massive. 4 extensions over 11 months shows courts were accommodating. Producing 4,300 documents isn't nothing. But documents also show Trump's vendor completed privilege review February 11th, 4 days before deadline, and cleared most documents for production. No filing explaining the final delay. No request for extension. Just missed the deadline. Both interpretations exist. What I'm showing you, the evidence trail, you decide what it means. Going back further, see how this connects. Different evidence, same pattern of deadline behavior. Hit, like, if this breakdown is making sense, helps me know this format works. Okay, the beginning, August 2025, 11 months before the contempt finding, before any of this was public, before anyone was paying attention. Here's what I found. Initial discovery order filed August 12th, 2025, Judge Engoron presiding. Nobody noticed. 67 pages, buried in thousands of documents filed in the broader civil fraud case. Page 43. Quote, defendant shall produce all responsive documents within 90 days. Given the complexity of defendant's business structure, the court will entertain reasonable requests for extension upon showing of good cause. That's 10 months before the contempt finding. Who saw this? Trump's legal team, on record acknowledging receipt August 14th, 2025. What happened? First production deadline, November 10th, 2025. November 9th, 1 day before deadline, Trump's team files motion for 45-day extension. Reason cited, volume of potentially responsive materials across multiple entities requires additional time for thorough privilege review. Judge Engoron grants extension. New deadline, December 23rd, 2025. Supporting detail, meeting minutes from case management conference, November 18th, 2025. 8 attendees, both legal teams plus judge's clerk. Topic, discovery timeline and cooperation. Outcome. Defense counsel represents documents will be produced in rolling basis with substantial production by December 1st and final production by December 23rd. So they discussed it, decided on rolling production. What actually happened? December 1st, 340 documents produced. December 23rd. No additional production. New extension request filed December 20th. Reason, holiday scheduling conflicts and ongoing privilege disputes. Judge grants second extension, new deadline, January 31st, 2026. Pattern starts here. January 31st, 680 documents produced. Another extension request same day. This time, Judge Engoron's order shows frustration. January 31st, ruling. The court grants defendant's third request for extension with the understanding this represents final accommodation absent extraordinary circumstances. New deadline, February 15th, 2026. What changed between then and now? 4 extensions granted over 6 months, partial productions each time enough to show effort, never a complete production. Always another delay request. First domino, that initial November extension. Established pattern, request extension day before deadline, produce partial documents, repeat. Everything else followed. Courts accommodated until they didn't. February 15th was marked final deadline in January order. Trump's team missed it without requesting extension. You can trace the line. August 2025 order, November extension, December extension, January extension, February deadline, missed, contempt motion, contempt finding, appeal, sanctions, appellate denial, today. Now let me put this in order. Stay with me. I'm about to connect all of this chronologically so you can see exactly how each decision eliminated the next possible escape route. What do experts say about this kind of pattern? Former federal magistrate Judge Nancy Gertner, 23 years on the bench. Repeated extensions followed by missed final deadlines typically result in contempt findings. That's standard civil procedure. Translation: once courts draw a line, crossing it has consequences. White-collar defense attorney Solomon Weisenberg put it differently. The issue isn't whether sanctions are harsh. It's whether the defendant created the situation through deliberate choices. Key insight there. Courts evaluate behavior pattern, not individual missed deadline. When you work backwards like this, appellate procedure expert Judge Andrew Oldham says, appellate courts review contempt findings for abuse of discretion. When the record shows multiple accommodations followed by non-compliance, reversal is extremely rare. Consensus among legal professionals. Pattern of delay followed by minimal compliance suggests willfulness. Once sanctions are imposed, appellate courts defer to trial judges' assessment. Daily coercive sanctions are standard remedy when defendant controls compliance. Former Department of Justice Attorney David Loffman adds context. In civil cases involving document production, the producing party controls the timeline. If documents exist and aren't privileged, there's no legal barrier to production. That's the key legal principle. The defendant has the documents. Defendant controls when they're produced. If deadline passes without production and without legal justification, that's the definition of contempt. Bankruptcy litigation specialist Jennifer Hagel: I've seen daily sanctions in corporate cases reach $100,000 per day. $50,000 for an individual defendant of Trump's wealth is actually moderate. Context matters. That's the expert read. So, put it in chronological order, fast version, August 2025. Judge orders document production within 90 days. November 2025, first extension granted deadline moved to December 23rd, December 2025. Second extension granted deadline moved to January 31st, January 2026. Third extension granted with warning this is final deadline, February 15th. February 14th, Trump's team emails AG indicating possible delay, no court filing. February 15th, deadline passes, no production, no extension request. February 22nd, NYAG files motion to compel and for sanctions. March 2026, hearings on contempt motion. June 17th, Judge Engeron issues contempt finding, $50,000 daily sanction starting immediately. June 24th, Trump files appeal and requests stay, denied June 28th. July 27th, emergency appeal to Second Circuit. July 29th, Second Circuit denies appeal unanimously. 11 months. That's the arc, each step documented in court filings. Could this have been stopped? Yes, at multiple points. Produce documents by any deadline. Request fifth extension with compelling reason. Produce the 89 disputed documents with privilege log. Why wasn't it? Legal strategy prioritized delay over compliance. Now what this means going forward. Like if this timeline clarifies how we got from discovery order to daily fines. The pattern's the whole story that like button helps. Why should you care? Real talk, how this affects you. Precedent. Next time you're involved in any legal proceeding, employment dispute, divorce, lawsuit, or remember this case, rules changed, patterns established. If you're ordered to produce documents in discovery and you delay, courts now have clear precedent for aggressive coercive sanctions. Example, you're in a business dispute. Court orders you to produce financial records. You think the request is overly broad, maybe unfair. You can object. You can request reasonable extensions. But if you establish a pattern of partial compliance and repeated delays, you're building a contempt case against yourself. That's the new standard. This case will be cited in civil procedure for years. Money. If you're ever subject to daily coercive fines, understand the math. $50,000 per day sounds manageable for a billionaire, but it compounds fast. Numbers. 30 days equals $1.5 million. 90 days equals $4.5 million. 6 months equals $9 million. What informed litigants are doing, taking discovery deadlines seriously even when they seem unreasonable, documenting every compliance effort in writing, never missing final deadlines without court permission, not legal advice, just what's happening in high-stakes litigation now. Who's affected right now? Anyone involved in complex litigation with document-heavy discovery. Corporate defendants in fraud cases already adjusting compliance strategies. Timeline. This precedent is effective immediately in Second Circuit, New York, Connecticut, Vermont. Uncomfortable truth. Wealth doesn't insulate you from contempt sanctions if you control compliance. If you're the party who has the documents, you're the party courts will sanction for not producing them. Not being dramatic. That's what the appellate decision confirms. Judge Netburn's order today. Financial capacity to pay is relevant to calibrating sanctions, not to whether sanctions are appropriate. Translation: being rich doesn't mean you're exempt, it means the fines can be higher. Practical steps: what you can do if you're ever in litigation. Treat discovery deadlines as non-negotiable unless you get court approval for extension. Ask your attorney, what happens if we miss this deadline? Resource to check: Federal Rules of Civil Procedure, Rule 37, sanctions for discovery violations. Your state has equivalent rules. Information matters. Understanding how courts view compliance patterns could save you money and legal jeopardy. What happens now? Immediate, Friday, July 31st. Trump's legal team has until end of business to file notice of intent to appeal to Supreme Court. August 5th. If Supreme Court appeal is filed, initial brief due. August 12th, NYAG's opposition brief deadline if Trump appeals. What's still unknown? Will Trump produce the 89 disputed documents to stop the daily fines? Will he attempt Supreme Court appeal despite long odds? Does he have $1.5 million in accumulated fines already, and will he pay? Reporting from legal outlets suggests Trump's team is divided. Some advisors recommending compliance to stop financial bleeding. Others pushing Supreme Court appeal on constitutional grounds, despite appellate experts saying chance of cert grant is under 5%. Trump himself reportedly insisting on continued legal fight. NY Attorney General's office preparing enforcement action if fines aren't paid within 30 days of accrual. That means collection efforts could start late August. Timeline to watch. Next week should know if Supreme Court appeal gets filed. Clock's running on compliance. Every day adds $50,000. Financial pressure versus legal principle. Subscribe. I'll break down what happens with Supreme Court decision, compliance choice, and enforcement. This isn't over, just entered a different phase where things stand right now. $50,000 daily fines active as of Wednesday, July 29th. No stay in effect. Trump has produced 4,300 of 4,389 requested documents. 89 remain withheld. Total accumulated fines as of today, approximately $1.5 million from June 29th start date. Scheduled July 31st. Deadline for Supreme Court appeal notice. August 12th. Next case management conference and underlying fraud trial. August 30th. Fines potentially reach $3 million if no compliance. Trump's current state: no legal mechanism to pause sanctions without producing documents or winning Supreme Court intervention. Not final yet. Supreme Court could theoretically grant emergency stay pending cert review. Legal analysts estimate that probability at 3 to 8%. Former Supreme Court clerk: the court rarely intervenes in discovery disputes. This would be extraordinary. Sanctions continue accruing regardless of appeal status unless court grants stay. Still moving. That's the full picture. Started with Wednesday's appellate denial, walked it back to August 2025 discovery order, every step documented in court filings. Surface read, Trump fighting unreasonable demands. But when you trace it backwards, 4 extensions granted over 6 months, pattern of partial compliance, final deadline clearly marked missed without explanation. Courts accommodated until they didn't. I'll keep following this. Working backwards shows you what working forward missed, how small decisions compound into unavoidable consequences. The legal strategy that worked for years: delay, partial compliance, appeal hit a wall when a judge said final deadline and meant it. Now we watch whether Trump complies, appeals to Supreme Court, or lets fines accumulate. Subscribe for analysis, not just updates. When the next filing drops, Supreme Court petition, compliance notice, or enforcement action, I'll break down exactly what it means and how it connects to this pattern. Stories still developing. See you then.